Welcome to the Deep Dive, where we cut through the noise and give you the essential map for complex, high-stakes topics. Today, we are pulling back the curtain on a massive, pretty hidden financial industry that is reshaping courtrooms all across the country. It's called Third Party Litigation Funding, or TPLF.
That's right. And TPLF is one of those things that, very few people outside of legal circles ever really see.
But its effects are everywhere.
Oh, absolutely. From increased insurance premiums to delayed justice, it really does touch everyone.
And our source material today is focused on a very specific, very high-stakes moment. We're looking at a formal letter dated December 5, 2025, sent directly to New York Governor Kathy Hochul.
Right. And this letter, it represents a unified front. I mean, you've got this coalition of major organizations from business, local government, critical infrastructure, and they are all demanding one single critical change.
Which is what our deep dive is all about today.
Mandatory disclosure of these TPLF contracts.
Okay, so let's frame this for everyone. What exactly are we talking about when we say TPLF?
At its simplest, it's when an external entity, could be a fund, an investor, sometimes a very large private equity group, provides cash to a plaintiff to fund their lawsuit. And in exchange, they get a percentage of whatever the settlement or judgment is at the end.
So it's like a speculative investment in a legal case.
Exactly. And the authors of this letter, they argue that this entire process is currently operating completely in the shadows. Nobody can see it.
And the whole debate right now is centered on New York's pending legislation. That's Senate Bill S-104A and Assembly Bill A-804C, also known as the Consumer Litigation Funding Act.
And the bill is supposed to promote consumer protections, but the coalition is saying that without an amendment for disclosure, the whole thing as well, it's fundamentally flawed.
So why should this matter to you listening right now?
The sources are very explicit about this. If the cost of litigation goes up, those costs don't just disappear, they get passed directly on to the public.
Through what? Higher insurance premiums.
Higher insurance premiums for local governments, yep. Higher costs for affordable housing. Inflated expenses for essential services like trucking and farming. Hidden costs in the court system always become public costs. That's the core of it.
Okay, let's unpack this call for transparency then. The coalition behind this letter is...
Yeah.
It's really remarkable, not just for its size, but for its diversity.
Yeah.
I mean, you have affordable housing groups right next to engineering firms and major business councils. What's the one thing, the common grievance, that unites all of them?
It's really about consistency and, a fair process. The coalition is basically arguing that the scales of justice are being tilted by invisible money, and they point out that New York already has a standard for transparency, but it's on the other side of the courtroom.
Right, the Comprehensive Insurance Disclosure Act.
Exactly.
And that act mandated that insurers have to disclose their policy information in a lawsuit.
Precisely. So the court, the litigants, they know the exact resources available from the insurance side. But when a third-party financier who might have invested, tens of millions of dollars into the case, is driving the plaintiff's strategy, that agreement is completely invisible.
So the defendant has no idea who they're really negotiating with.
None. And the judge has no idea what financial incentives are actually driving the case forward.
So the coalition is really just asking for a level playing field. But
Yeah.
Let me just play devil's advocate for a second. If a private person wants to fund their own lawsuit, or maybe get a personal loan to cover costs, that loan is usually private too. Why is TPLF different?
That's a great question, and it comes down to two things. Scale and motive. This isn't just, your Uncle Joe funding a small claims case. These TPLF entities are sophisticated financial players. They're investing millions across hundreds of cases. And their primary loyalty isn't to the plaintiff or to justice. It's to their investors' return.
They're looking for a high yield.
A guaranteed high yield. And that massive profit-driven incentive is what the court is currently completely blind to.
And you can see how this affects specific sectors. The New York Housing Conference, for example, notes that TPLF's scope and impact remain obscured.
Mm-hmm.
Why does a housing organization care so much about this?
Because they're facing constant liability risk. Slip and falls, property issues, construction disputes, it's constant. When TPLF gets involved, these lawsuits just drag out, the costs escalate, and the overall risk for affordable housing providers goes way up.
And that has to impact their budgets.
Directly. It impacts their ability to get affordable insurance, which in turn hinders new development, maintenance. The money they spend on these long legal battles is money that's not being spent on keeping rents down.
And it's not just private groups. We even have powerful government voices chiming in here. The Corporation Council for the City of New York is supporting legislation that requires transparency.
It's rare.
It's very rare to see such a diverse alignment of business and government on such a technical legal point.
It just underscores that this isn't some niche issue. It's a systemic risk. And it connects right back to you, the consumer, the taxpayer. When the City of New York faces longer, more expensive lawsuits because of these hidden incentives, those costs show up in the city budget, in project delays, and, yeah, eventually in your taxes.
So the secrecy allows financial pressure to influence judicial outcomes.
And we all end up paying for it.
This brings us to the operational consequences of all this. And this is where it gets really interesting, because the sources claim there's a direct line between TPLF and just dragging out litigation, which is what drives up all the costs.
You have to understand the financial incentives. If a TPLF entity invests, say, $100,000 into a case, and their contract says they get 40% of the outcome, they're going to push for the absolute biggest judgment possible.
Even if that means rejecting a reasonable settlement, that would actually help the plaintiff right now. So the financier, who isn't even the plaintiff, gets a say in the negotiation and could just say, nope, we're not taking $1 million, we're holding out for $2 million. Even if it means years more of litigation and stress for the actual person who is injured.
Exactly. And the source material points out that lawsuits in New York already take longer to resolve than in most other places. So adding this powerful hidden incentive to drag things out, it's just throwing fuel on an already burning fire.
And this is where the sources introduce this kind of chilling term, zombie litigation. What are they describing with that phrase?
It's a very vivid description. It's for cases that really, by all rational legal standards, should be settled or maybe even dismissed. But instead, they're kept alive, like The Walking Dead, because of this hidden financial life support.
TPLF contract?
The TPLF contract acts like a transfusion, just pumping in money to fund more legal action, more expert witnesses, more delay tactics.
So it's not just a general delay. It's a specific pattern where a case that everyone knows should be over. The judge, the defense, maybe even the plaintiff's own lawyer. But it's being kept going because the funders need to maximize their return overrides everything else.
Precisely. The funding lets the lawyers take a sort of no-risk approach to delay. They can afford to appeal every single decision, conduct endless discovery.
Because they're not footing the bill.
The funder is. They're carrying the financial burden, waiting for that one massive payoff. And without disclosure, the judge has no idea this is happening. They just see a plaintiff who looks unreasonable when really that unreasonableness is being financially mandated by a hidden investor.
Wow. And that lack of transparency leads us to the most disturbing part of this letter. We're talking about serious allegations of, well, alleged criminal activity. This goes way beyond just financial efficiency. The sources claim TPLF is being used to underwrite actual fraud schemes.
Yeah, this is really heavy stuff. It completely changes the conversation. The sources allege that TPLF has been found to underwrite organized, fraudulent civil litigation schemes. And these schemes involve coercing vulnerable and marginalized people.
Coercing them to do what?
To stage accidents, low-speed car crashes, and then to undergo expensive, totally unnecessary surgeries.
All to just inflate the claim.
All for the sole purpose of generating massive medical bills to create a paper trail of a significant injury and inflate the final value of the claim. They are literally manufacturing a lawsuit from scratch.
So the TPLF money isn't just funding a claim that already exists. The letter is alleging it's funding the creation of the claims. It's like a business model where the lawsuits are fabricated for maximum investor return. That sounds huge.
It does. And the letter specifically cites findings from a recent study by the Portman Square Group on TPLF in New York. And I'll quote it. It said, TPLF is now at the heart of a sprawling ecosystem involving corrupt doctors, lawyers, financiers, and organized crime.
That is a staggering claim. You're bringing together finance, law, and criminality all in one sentence. So how does disclosure fix that?
The coalition argues that mandated transparency would be an immediate preventative measure. Think about it. If a case is built on a staged accident and fake medical bills, and that TPLF contract is visible to the court from day one,
it raises a red flag immediately.
Immediately. The court could scrutinize it, identify suspicious funding patterns, and get law enforcement involved right away. Right now, because the contracts are invisible, the courts have no way to spot the criminal enterprise being funded until it's way too late.
The secrecy is the shield. It allows the crime to operate with impunity. So this shifts the debate from just a financial regulation issue to a public safety concern.
Absolutely. And that leads us to the final critical point in the letter. It's the enforcement problem within the existing bill itself, S1104A. If the whole point is to protect consumers, how can the coalition warn that this law, as written, will invite more fraud?
Okay, let's get into the legal drafting here. What's the loophole?
It all focuses on accountability. The bill's current enforcement provisions, they only apply to violations that are found to be willful. And on top of that, the penalties are capped at a meager $5,000.
Okay, so you have to prove intent, which is incredibly hard,
Right.
and the punishment is tiny. That just sounds like a gift to bad actors.
It is. I mean, think about what willful means. If a TPLF firm writes an unlawful contract to prove it was a willful violation, you have to prove they knew it was unlawful and they intended to deceive. But if the law doesn't require them to even show that contract to a judge or the other side, how on earth could you ever prove that?
You can't. It's impossible.
You can't. The lack of transparency makes the weak penalties and the willful requirement totally meaningless.
If the contract is hidden, you don't even know a violation has occurred in the first place.
It creates a law that is structurally incapable of being enforced. If an organized crime scheme is making millions by funding staged accidents, a $5,000 fine, which they'd probably never even have to pay, is just the cost of doing business.
It's no deterrent at all.
Zero deterrent.
So the coalition's final warning is pretty profound. Enacting this legislation without the disclosure parts would basically legitimize the industry while making sure the new protections are completely unenforceable.
It would invite litigation. It would encourage fraud by creating this shield of false legality, drive up costs for the state, and ultimately leave consumers totally unprotected. They're calling for an integrated solution. You have to pair the protections with transparency. One doesn't work without the other.
So what does this all mean for you listening? This unified voice, from the Trucking Association of New York to the New York Farm Bureau, all the way to the iFraud Foundation, they're all focused on one single, non-negotiable point. Transparency is the one ingredient that's missing for any of this regulation to work.
It's a remarkable convergence of interests. It's not about partisan ideology. It's not about whether lawsuits should exist. It is purely about the structural integrity and the cost efficiency of the justice system itself. The message is simple. The law needs to reflect where the money is really coming from. So, bringing it all back together for you. This bill aims to protect consumers, but without mandating the disclosure of the financial contracts that fuel the lawsuits, those protections are likely unenforceable. And the court system stays vulnerable to hidden manipulation and alleged fraud, driving up costs for all of us.
And if we just zoom out to the bigger picture for a second, think about how the simple presence or absence of a disclosure rule just fundamentally changes the balance of power inside the judiciary. Disclosure doesn't just show who is funding the suit, it shows why the suit is proceeding the way it is. It ensures that judicial efficiency is the priority, not maximizing returns for some invisible investor. The moment that kind of money enters the justice system, sunlight becomes essential.
The core conflict here really is between transparency and opacity, and the cost of that opacity is borne by the public. So we'd urge you to consider the broader implications here. Think about how many other areas of commerce and law operate under a veil of secrecy, and what is the true hidden cost of that opacity to the public treasury, to consumer safety, and ultimately to the integrity of our institutions. That's something to chew on long after this deep dive is done.